make a phone call or send a message, please step outside. Thank you.
All right, we are here for the King case, 25 CA 5565. If you'll note your appearances, please, starting on the plaintiff's side.
Good afternoon, Your Honor. Morgan Bentley on behalf of John King and Karen Woodson. At council table is Mr. King and Ms. Woodson. To my right is Andrew Van Ness, who
Very good, thank you, sir. We sound the hallway for Mr. Veach and Mr. Murphy. Veach and Murphy. Okay, you're one of the parties. Where's your lawyer at?
It's just not mobile.
Okay. Sound the hallway for Mr. Pizzi, please.
Right now, Ray and Bill are waiting for their attorney, who isn't here in the courtroom.
That was the old notice, but we sent out a new notice. Okay. We sent out a new notice on May 29th, setting it for 5 eyes, since there was a request for media room. If you wouldn't mind, just run downstairs real quick.
You see John and Karen at the table, and Ray's waiting for the attorney. As long as they stay close to their mics, we should be okay. See, Karen and John have a little audience behind them there, some folks from the community. You're behind a one-way mirror in the media room.
You two are welcome to sit at the table. Hopefully your attorney shows up, but if he doesn't, we'll go forward with that.
He told me his ETA. So what happens is then
It's 1:30, quarter till is long gone, and the hearing is scheduled for 2 o'clock. So if you're gonna hire a Miami attorney, you need to ensure he's gonna get here on time, which means he needs to leave there 3-4 hours early in case there's an accident or something otherwise. So we're checking downstairs, and we'll start here shortly.
Not a good start for Ray and Bill. Yep. Deputy went downstairs to check and see, because they changed the courtroom because we needed the media room.
Yes.
Appears the deputy said.
I hear a phone. There should not be phones on in the courtroom. Please step outside.
It's not me.
it's 5 eye. 5 eye.
No phones in the courtroom, and Bill is talking to the attorney.
All right, I'll step off when he's here. You let me know. Okay, you can keep your seats, folks.
We're just going to keep the stream going, everybody. The judge is a little ticked off that Pizzi did not show up on time. Apparently, he's in the building somewhere. We cannot find. It is a big building. I got a lot of steps in, but I also got here an hour earlier. I don't think they'll hold him in contempt. I don't think this is going to take 3 hours anyway, so. Can you guys hear me okay? I don't know. Hopefully they'll stay close to their mics, because the speaker is in the ceiling here. Can you hear if If you can't hear what's going on in the trial, I have a backup mic that'll try and connect. John King did not wear shorts today, so that was a good thing. Kim and I were wondering this morning. All right, well, we'll see how it goes. As long as they're loud talkers, they should be okay. I got a backup mic here, but just adding to the drama. They almost didn't let me in. The guys downstairs had no idea what was going on. There are no cameras allowed in the courtroom. I did not know that. In New York, there were cameras in the courtroom. We just had to get it approved by the judge. No cameras in the courtroom here, but some of the courtrooms have media rooms like this. It's not really a media room. It's a cubby hole with a dirty glass window. There he is. And we're probably going to get rolling here. And the reason we're here is because Ray and Bill have asked for this defamation suit to be dismissed. Pizzy was once on a council somewhere down in Miami, and he got kicked off, so he knows all about this kind of thing. And then he went to court and won the court case, but it was years later, and somebody had already been in his seat. I don't recall if he got his seat back. He might have got his seat back eventually, or ran again. He's a talker. He likes to talk. This will not be carried live on Court TV. We are now 8 minutes after 2. Very clean bathrooms here, by the way, if you're wondering. See Karen's husband in the crowd there. Also Bev Milligan and her husband are here. Danielle from the beach. On the other side in the crowd, nobody. I didn't need it, Holly. Not yet, anyway.
Just keep your seats, folks. All right, as a final reminder, if you have a cell phone, please ensure it's turned off and put away. If he sees it, it's getting taken or you're getting kicked out. All right, we've done record appearances. Mr. Pizzy, if you'd like to note yours since you're 10 minutes late.
I'm sorry, I was driving from Miami and I got a little lost, but I apologize. I'm happy to be here. Thank you.
Okay, thank you, sir. Plan accordingly. Everyone comes from somewhere else. They're from Sarasota, you're from Miami. People come from all over, but you gotta be sure you're here on time because what's your hourly rate?
Hourly?
$250? And what's your hourly rate?
$650.
$650.
$650.
So $900, you know, what's 10 minutes of $900?
No, I'm not good with math, Judge.
A little more than that? All right, so let's move forward. At the last hearing on May 7th, the court specifically said, quote, for the clerk's minutes, Both sides need to prepare physical notebooks. for
Pizzy
case
did not
law,
prepare a notebook. I heard you
affidavits,
talking
and
about
any
it.
appropriate evidence.
before.
Those collected documents need to be provided 2 weeks in advance. I received a nice big fat notebook, other things from the plaintiff's side, but I didn't receive a notebook from you. Did you not do one as I directed you to?
Well, we sent in a notebook on May 6th. And I was under the impression that we sent in a copy of my notebook for today, but I will hand the court my notebook.
I don't want to take yours if you need it.
No, I don't need it. I'm going to give it to you. I have it memorized.
Okay, fair
You have
enough.
my notebook. And it's good to see you, sir.
Nice to see you as well.
What you speak?
But I would appreciate it in advance because I have read through theirs and I've not read through yours.
2 strikes.
All right, so we'll go ahead and go forward. The issue for today, there's a couple, would be the motion to dismiss, and I think there's the discovery-related issue too, or concerns on this end as well. All right,
I'm ready to proceed, Your Honor.
Yes, sir.
Is there a podium or is that me speaking?
you can speak from your table if you like. If you prefer the podium, I can have it brought out to the middle, whichever you prefer.
The podium's a little bit better for me if I can have it.
Okay,
Good,
that's
because we got a
Also,
microphone.
just a little, I only hear out of one ear these days, so the closer I get.
Which ear's the better ear?
My left ear.
Okay, so why don't we put the podium over there, and you'll hear me a little
Good
bit better.
grief.
For your edification, there's media in the back behind the glass, so they'll get a better view of you that way too, if they like. Okay?
Sure, Your Honor. Good to see you. Glad to be here, Fort Myers.
Thank you, sir.
No microphone.
Yeah, I know you said it's 3 hours. I assume it's an hour and a half for each.
Well, 3 hours is an abundance of caution. It's more than enough time. So hopefully you don't need an hour and a half each, but
I can
take
go
as
ahead.
much time as you reasonably need.
Thank you. Please,
Yes, sir.
Michael Pizzy, on behalf of William Veach and Raymond Murphy, who were present before the court. We hear on a motion to dismiss. This is an extraordinary case because the plaintiffs who were the subject of recall petitions that were submitted under Florida statute 361 and were recalled by an overwhelming majority of the landslide.
I thought only one was recalled. Were they both?
I'm going to get that. They were both recalled in a landslide by the people, but the judge found a defect, a technical defect in one of the petitions. I think it was Mr. King, indicating that,
Defect's a defect, so only one ended up being recalled at the end of the day.
yes,
That was Ms. Woodson, correct?
they were, yeah, Woodson and King were both subject to recall petitions and a recall vote, where the electorate voted in by a large margin to recall both of them. One of them was removed, the other one is still in office because the court found that there was a defect in the petition, and both are now on. So they were both subject to recall petitions and voted on by the. So what's extraordinary about this case, Your Honor, is that Florida statute gives citizens the right to engage in recall petitions and petition their government. Every citizen has a right to constitutional right in the First Amendment of the Florida Constitution to petition the government. In this case, we have 2 specific statutes that are in play, in addition to the common law. One is Florida Statute 768.295, the so-called SLAP statute, which I'm going to talk about a little bit. And that statute, the policy in that statute is to prevent plaintiffs from dealing with the plaintiffs and the lawyers are trying to do before Your Honor, which is to sue people for the primary purpose of political speech and political grievance they grievance. So the first statute, and we'll talk about it a little bit, is Florida Statute 768.295, the SLAP statute, which is the policy in the language of that statute is to protect every Florida citizen, protect their right to petition, speak at meetings and petition their government, and express their opinion about their elected officials, and circulate petitions and engage in redress. It has to elucidate a little bit. In this particular case, they're being targeted and spending a lot of time and money on lawyers because directly because of the participation of government. It's not a case where they're saying, well, they said things about my family, they said things. This is the case where it says the lawsuit, shockingly, the lawsuit specifically says on the face of the complaint, they're targeting them because of their participation in recall committees, which they have a statutory and constitutional right to. I don't think there's any case, not really any case, where anyone's ever, a plaintiff's ever survived the SLAPP statute, where they specifically said, and I appreciate their honesty in the lawyers, but they specifically said, they didn't hide it. They didn't say, well, you know what, we're suing Veach and Murphy because they went to Starbucks and said that I was a bad parent or whatever it is. They're not saying I'm suing Veach and Murphy because when they were knocking on doors, circulating the petition, they made comments and said I was a bad accountant, or a bad lawyer, I was a crook, a tax cheat, whatever. They explicitly make it clear to your account and make your decision a lot easier because the lawsuit is, they explicitly state we are suing them with defamation because they circulated a recall petition. They had the right to circulate. It was actually certified by the court, went to a vote, and was set for an election by the chief judge. The second argument,
Well, I don't think they're contesting the right to petition in that regard. They're contesting the statements that were made in the context of that petition, correct? So that's the issue, right?
well, I think that they have absolutely no right under the SLAPP statute and under the Florida statute and under the Florida Supreme Court's decisions on defamation. They have no right to sue them or any other citizen because of the content of a recall petition that went through.
I think they would agree with you on that, but their position is the SLAPP statute doesn't protect defamatory statements. And that's their position, is it not? That allegedly your clients made defamatory statements in the context of the distribution or within the context of the petition itself.
They're not saying that they made defamatory comments
They are saying that.
engaging in distribution. They're stating that the recall petition that was certified and that they distributed as part of the recall committee is stating that those grounds are defamatory. Those grounds are not true.
And grounds set forth in the petition itself.
That they circulated as chairs and as part of the recall committee.
That's the alleged defamation, correct?
Absolutely.
Okay.
And I'm going to explain why that should be dismissed. There are 4 reasons to dismiss the ground number one, Your Honor, they don't plead the elements of defamation as part of it. And I'm going to outline the 4 reasons for dismissal and take a few minutes and explain why each of the 4 reasons individually is a basis to dismiss them. Reason number 1 is that they don't plead the elements of defamation in the law by an extremely bare bones complaint. They lump together their roles as individuals as participants, as chairs of the 2 recall committees. The recall committee to remove Woodson and the recall committee to remove King. And they don't state that they made any comments outside and circulating to the recall petition. So one of the problems is in defamation. You need to say that Mr. Veach and Mr. Murphy on X date made the statement. This lawsuit must be dismissed because it's kind of a jumbled mess, because what it does is and I'm going to cite the particulars. So number one, they jumble everybody as part of the recall committee together. And based upon the language of this, anyone who circulated the recall petition will be imputed to class if be sued the way they pled this. And I'm going to get to that. Let me state the other three ones.
Isn't that permissible? I mean, you can have 5 people involved in a car accident and say, I only want to sue 2 out of the 5. That's up to them to decide how many alleged tortfeasors they might want to sue, right?
They're required to plead that Veach specifically make statements in an individual capacity. And when you sue somebody as chair of a committee, you're suing the committee. And one of the fatal flaws of this lawsuit, get to this thing.
Is the committee a corporate entity? Or is it just kind of a made up, we say there's a committee, but there really isn't, and it's driven by individuals behind the mask?
Well, Florida statute 100.361 sets what the parameters, that they're required to follow the court's law stating that this is a committee recall. And everybody, under the foreign law, everybody who signs the petition becomes part of that, becomes part of the recall committee. So assuming
If you sign the petition, you're part of the committee?
yes, exactly.
So if they prevail in suing one of your 2 clients or both in their capacity as a committee representative, are you saying then that they can go after anybody that signed the petition to try to get payment of any judgment they may get?
Let me look at their, as ridiculous as it is, that's they play. And let me look at their.
My question to you, though, is you sued them in the capacity as this committee. You know, ABC Inc. is an entity or a corporate entity that has an ability to be sued directly, or ABC Company. Is there any formal company or incorporated entity, i.e. this committee is its own entity in and of itself?
Because number one, I've seen people seek conjunctive relief against recall committees in general. Say the recall committee and members cannot do X, Y, and Z. No different than you could against the LLC or sole proprietorship. But if you look at the complaint, if you look at the attachments, exhibits A and B to the complaint, which is the petition that's sent to the voters, it says as follows, and I quote exhibit A and B in it. Quote, upon signing this petition, you become part of the recall committee. Chair of the committee is William Veach. So let's be abundantly clear. The petition that they attach to their lawsuit says every single person who.
Yes, we all know that. Everybody that's on the committee, everybody that signs is on the committee. They're suing Bill and Ray.
Committee. That's not what I'm saying. That's what it says.
Judge isn't buying it.
The question is, are you saying that some poor slob is out there, signed the petition and said, hey, I agree with this, I think this is true, and I want to sign this. Everybody's become part of the recall committee, and could be, if their theory is correct, yeah, every citizen who signed the recall petition could be sued as part of a recall committee. And if you look at the complaint, and if that's what they're asking me to hold. Because if you look at the complaint, there's no allegation.
But what I'm getting at is there some committee that's incorporated that has assets that you could recover your judgment on, or are we just spinning our wheels, suing them in their capacity as a committee member? Is there some entity that's legally recognized as being a committee that could compensate your clients if they recover against them in their capacity as committee members? I'm looking at you all, not him.
Okay, yeah, so didn't know if you wanted to think yes or no. Technically, no, there is no corporate entity. This is one of those, and as you know, the law is pretty clear. You have corporations, you have individuals. The reason he's joined is actually, he's saying that's why he's joined in that way. We joined him in that way because he is in that, Mr. Veach. they were both individually and on each of the petitions listed as the chair designate. So we're listing the chair designate, but there is no committee. There's no corporation that has assets in the name of the committee to recall. Like, for instance, it would be called the committee to recall John King. There is no such animal. It is correct that the statute does say that every person that signs becomes a member of the committee, but there is no corporate committee that is separate and apart from the individuals themselves. So, in a method, in a way, yes, if the question is, are we spinning our wheels about collecting judgment against the committee? The answer is yes. There is no committee to collect against. If we are covering our bases as to which hat Mr. Murphy or Mr. Veach was wearing, whether it was just purely individual or purely as chair, that's why he's pled in both those capacities. There is no committee to collect from. Nor do we make any allegations against the committee as a whole. We only make the allegations against Mr. Veach and Mr. Murphy.
The short answer is the Florida statute 100.361 says you're required to form a recall committee in the city, and if you're not proceeding as a committee of people, you can't. So, the second point, that an independent basis for dismissal, a second independent basis for dismissal. Number one, they haven't pled the course of action. Number two, they haven't properly pled express malice under the Florida common law and under New York Times or so. And as my colleagues on the other side admit, in addition to pleading actual malice, New York Times or so, in Florida you have to plead express malice, which was that your primary intent was to inflict harm. Something you knew was not true.
Well, that's the Nodar case as well, from the Florida Supreme Court case, yes. Nodar.
Yes, I'm going to talk. So, Judge, I think, let me first start with the point number one. Point number one.
You want to tell me what the other 2 points are, and then you can go back to one?
Sure. The other points are that they violate the SLAPP statute 716.295, and they actually violate 100.361, which is the Florida recall statute. So if they violate the recall statute 100.361, they violate the SLAPP statute. They haven't pled malice, and they haven't pled a course of action because they haven't pled any action against Veach or Murphy, other than everybody else in the recall committee and the recall petition did as part of the petition. Let me point to the complaint, because that's what we're here. Right? So let me talk about the complaint that I have in front of me. Here's the complaint. If you look at paragraph 9 of the complaint, paragraph 9 says, Mr. Veach, as chair of the committee to recall, drafted and circulated the petitions.
To recall John King. You have to read it as it's written.
Correct. And with regard to Murphy, they state with regard to Mr. Murphy, paragraph 21, with regard to Mr. Murphy, that same allegation against Woodson. So paragraph 9 with regard to Mr. Veach, and paragraph 21 with regard to Mr. Murphy state explicitly that they're suing them because, quote, as chair of the committee, they drafted and circulated a recall petition. So, suing somebody as chair of the committee is suing the committee. Now, maybe if they would have said the following, you know what? While they were circulating the recall petition, Mr. Murphy or Mr. Veach made some defamatory statement about them, separate and aside from circulating the petition, but they specifically said that they're suing them on the count 1 and 2, they said that they're suing them, quote, as chairs of a collective committee with a whole bunch of other people who supported the district. Second, paragraph 11 and 22, paragraph specifically states, quote, first 9 and 21, Veach and Murphy state that they're being sued as chair of the committee, the collective committee of a whole bunch of people. Paragraph 11 and 22 state that as part of the petition, and
Mendacious petition.
I'm not sure what mendacious, I'm a kid from Brooklyn, I'm not sure what mendacious means, but I'm gonna look it up before this case comes. What I will tell you, Judge, is that, thank God for Google. What I will tell you, Your Honor, is that whatever mendacious is, I think they're saying that that what they did in 11 and 22, that Veach and Murphy, whatever they did quote as part of these petitions. And then if you look at exhibits 1 and exhibit 2, which are part of the complaint, pursuant to part of the complaint, what they show is the following. Paragraphs 1 and the exhibits show that, number 1, as we stated already, as part of signing this, you become part of the recall committee, the same as Veach and Murphy, which means that, I guess, thousands of people are part of the recall committee, and I guess if they read about this, I guess they'll be sad to know that some people think that everybody who signed this petition and circulated it, I think, no, mistaken. Look at exhibits A and B. Anybody who signed and circulated this petition today would be subject, 1,000 people would be subject to a lawsuit for defamation. Second point is that the petition is signed, and actually each petition is signed and submitted by each individual person. So they attach this, thankfully, and that's what it shows. I want to get to my second point, which is, so I think that, could be wrong. But I'm proud and willing to make that that's ridiculous. You can't sue King and Veach for defamation with their participation, with their collective participation in a recall petition supported by the people as chairs. That's absurd, and that cannot stand. I'll get to my second point about Dallas. If we get there, the second point is, under Florida law is very clear that when you sue somebody, you actually have to plead actual malice under federal constitutional law. Must be shown for a public official, public figure can be covered for defamation. You've got to show that it consists of knowledge of the falsity, reckless disregard for the truth.
Well, it's knowledge of the falsity or reckless disregard of the truth or falsity.
The New York Times example, and but on the Florida law, you've got to show express malice, and in my colleagues brief, he says, we acknowledge you've got to show an express malice under the Florida common law to overcome the common law qualified privilege. To overcome the common law qualified privilege. I don't see this as a comment. You've got to show no law v. Galbraith, no law v. Galbraith, 462, second 803, Florida Supreme Court 1984. You've got to show the primary motive of the state. This is an intention to injure the plaintiff. So in the note on the Galbraith, Florida Supreme Court said that you have to show the previous express malice of Florida. You've got to show the primary motive of the statement is to an intent to injure, and you have to show malice for clear influence of the evidence. And there's got to be sufficient evidence that the conclusion that the defendant, at a minimum, entertains serious doubts as to the publication. But I would say that the note on the Supreme Court makes clear, you've got to show the primary motive was to injure the plaintiff. And what I will tell you, and that's note on and real time result of 376 U.S. 254, you've got to show reckless disregard for the truth, and you've got to show express malice. Now, there's a reason, and that is that citizens of the United especially the political companies, have an absolutely God-given constitutional right. The Florida Constitution and the First Amendment. If they want to get up and be critical and bang a pot and pan and knock on doors and make critical comments on public officials, from the president down to local community councilors, down to the dog catcher. They work very hard, down to the dog catcher. They have an absolute right to do that, and the reason you have the malice stand is you don't want citizens who want to say, I don't like this president, I don't like the former president, the current president, the future president, I don't like this council member, I don't like this person who's the parks commissioner. You want to shield, it's the job of the courts to shield those people and protect those people. You don't want to have a situation in Fort Myers, especially now. In Fort Myers, we might have a situation where we're going to chill the First Amendment of Fort Myers, and everyone's going to be afraid to criticize the commissioner, and someone's going to say, you made a mistake, you got it wrong, and they're now going to get sued. And we look at the complaint based upon that standard, and how the pleadings are woefully inadequate. I will tell you, Your Honor, what will not satisfy the malice standard. And you know what? In my younger days, I tried it and got slam dunked enough time, so I realized you can't do that. It would be nice if you could just say the defendants engaged in reckless disregard for the truth, and the defendants didn't do the due diligence, and they either intentionally lied, they engaged in knowing falsity. The defendants had a primary intent. And on the Florida law, Judge Conley, and by the way, on behalf of my clients, we appreciate the time allocated for this.
Oh, God.
But in Florida, you can't just plead the magic words, because respectfully, the malice standard and under U.S. Sullivan and the express malice standard and the no-law cases, the no-law standard, that would be absolutely meaningless. If lawyers can just say, just plead the magic word, we can just plead the magic words, then the malice standard is meaningless. Because then here's what's going to happen. And then I'm going to explain why they're pleading non-sufficient. If people are allowed to survive emotionally, the court plays an important role as a gatekeeper in defamation lawsuits, with or without the slash statutes, especially when you have citizens engaging in petition drives or criticizing commissioners or presidents. And if this court were to rule, or any court were to rule, that as long as you plead the magic words.
What he's trying to do is say that that when Bill and Ray accused Karen and John of violating the Sunshine Law and taking gifts from developers, that's just criticism. That's what he's trying to say. And you should be allowed, obviously, you should be allowed to criticize public officials, but that's not what John and Karen are saying.
At least maybe later on summary judgment or a trial, but no court would ever dismiss a defamation lawsuit if they could just plead the magic words. Here's what they've pled. If you're on a motion to dismiss on, we don't know what they pled. They pled is the following. They pled, quote, first of all, you know how you know that they didn't do their homework and plead alternate facts? Or plead, yeah, okay. Maybe they're going to argue you can prove malice by circumstantial evidence, okay? Well, they need to plead to meet this heavy burden of express malice in Florida. They need to plead something more than they pled. And here, you know how you know that they haven't met that burden? If you look at the counts against Veach, and you know how you know they're too formalistic and boilerplate, because if you look at the counts against Veach and Murphy, they're identical. In terms of pleading malice, they just inserted the same boilerplate for Veach as they did for Murphy. So they should have at least changed the words a little so it looked like they actually were pleading specific facts, but they pleaded boilerplate. Here's the boilerplate they pleaded. And paragraph 14. Paragraph 14 says that Veach was invited to present evidence and didn't do it.
If you're gonna read it as it's stated. Mr. Veach has been invited on multiple occasions to present evidence to support these lies. He has not and cannot, as his allegations are wholly based in falsehood.
Well, respectfully, stating that somebody has been invited to present evidence during proceedings or whatever.
That's an irrelevant allegation. I don't disagree.
Yeah, that's irrelevant. So with all due respect, the fact that pleading that he was asked, hey, come show me the evidence, and didn't do it, that absolutely does nothing to establish what his primary motive was, or that he knew any information was false. So paragraph 14, and if you look at with regard to here it is, paragraph 25, quote, with regard to Murphy. Despite having multiple opportunities to present evidence supporting these fallacious allegations, Mr. Murphy has not done so, nor can he as claimed. So those two statements don't show trespass. Next, what else did they? How else did they try to meet that standard?
Well, they did use the word maliciously published. Does that not satisfy the malicious aspect from your perspective? I'm sorry?
No, absolutely not. Just using the word malicious doesn't, just throwing that word in there doesn't, is meaningless. You can't just put the magic words. Here's what they've said. Here's what they've said in addition to that. They've said in paragraph 13. I've learned in the past 2 minutes that when I quote a paragraph, I'm going to read it later on. I'm a quick one. So on paragraph 13, you're right.
Well, I see it, you see it, he sees it. Those folks don't have copies of it, nor do the folks that are watching online or wherever they're watching.
Just talk radio, Judge, say it.
Mr. Veach maliciously published these statements with knowledge of their falsity and reckless disregard.
You didn't read it. Read it again.
Mr. Veach maliciously published these statements in the King petition with knowledge of their falsity and reckless disregard. Actually, they treated the falsity. And with regard to Mr. Murphy, it says, oh, here we go. Paragraph 24. Ms. Woodson denies Mr. Murphy's sham claims as these events never occurred and as the allegations are wholly false. Mr. Murphy maliciously published these statements in the Woodson petition with knowledge of their falsity or reckless disregard for the truth of the falsity. That just takes the New York Times some of the malice standard and as boilerplate and just puts it there. That, from a factual perspective, that is never enough. It's never enough. In Florida or federal law, just boilerplate, somebody is preparing a lawsuit, somebody back in the office, well, you've got to show malice. Okay, let me go. New York Times v. Sullivan, how do you show malice? Well, you've got to show that they did it with knowledge of their falsity or reckless disregard for the truth. Okay, Mr. Murphy and Mr. Veach acted with knowledge of their falsity and reckless disregard for the truth. That's simply
He did.
quoting what the standard is, and that's conclusory. That does not meet the standard for trespass. Finally, what else do they say?
Finally.
They say in paragraph 10 that they say that Mr. Veach published the King petition to members of the community with the intent of tarnishing King's reputation in the news based on false allegations.
You keep not reading portions of it, but go ahead.
Yeah, Mr. Veach published the King petition to members of the community with the intent of tarnishing Mr. King's reputation and having him removed from office based on false allegations and lies. Mr. Veach was the person who endeavored against Mr. King, thus spread these brazen and insolent lies sole purpose of having this could name a petition or petition. What they don't do is, they don't provide any details, they don't provide any details as to the how, the when, the why. It's just a conclusory statement that it's filed, but it does not print its motive, it doesn't print any details as to the how, when, and why. I want to jump to number 4 before I go to the stop statute. And that is why this violation is inconsistent with Florida statute 100.
He says what the lies are in paragraph 11, right? The alleged lies.
Well, they're saying everything is, they're saying,
No, it's not saying everything's a lie.
I'm prepared to read it.
As part of the mendacious King petition, Mr. Veach falsely states that Mr. King, 1, engaged in private conversations to coordinate with council member Karen Woodson, soliciting a replacement town attorney. 2, received unreported gifts of meals from parties who were seeking land use approvals from town council. And 3, dictated the removal of multiple town contract employees. Mr. Veach further falsely states that such actions amount to misfeasance and malfeasance of Mr. King's official duties. So those are the alleged defamatory statements.
Well, they're just quoting the petition.
Correct. He was saying that the prior paragraph 9, which is attaching the petition, that there were quote categorically false close quote statements or allegations, and then he specifically identifies what those allegedly false or defamatory statements were or are.
Well, yeah, correct, but what I'm saying is, those statements are the statements that are agreed. There's nothing.
Right. He's not saying that outside of the petition, when they knocked on Sally Sue's door, they told Miss Sally, you know, Mr. King's a dirty, rotten scoundrel, and he likes to deal drugs, and he shoots up heroin every night.
Oof.
I mean, that's just an
Judge.
example. Not to say that he does.
But the point, and you're correct, but what they're quoting there is not a syllable different than what's in the circulated. If you look at the Florida,
Well, you're not asserting there any other defamatory statements, are you? It's just those 3 as extracted from the petition, right?
yes,
Okay.
so if you look at the Florida recall statute 100.361, it states that Florida recall statute 100.361, and if you look at I think I tapped it off there, it should be in there.
Well, it's
Anyway, what it says is as follows. 100.361.3a. Upon receipt of a written determination that the requisite number of signatures has been obtained, the clerk shall at once serve upon the person sought to recall a certified copy of the petition. Within 5 days after service, the person sought to recall may file with the clerk a defensive statement not more than 20 words. Subsection 3, Florida statute 100.361. Recall petition and defense.
Yes, he did, Kelly.
Within 5 days after the receipt of the defensive statement, or after the last date of defensive statement could have been filed, the clerk shall prepare a document entitled Recall Petition and Defense. The recall petition and defense must contain lines which conform to the.
Yes, we know all this, Pizzy. We know all this.
your skipping parts.
And so if you look at in tabs 8 and 9, if you look at the packet that I sent them on May 6th, the last 2 documents, 8 and 9, it's in front of the file.
I don't have that.
It's the last 2 tabs where you get to. And what it says is as follows. We attached a copy, can attach a copy of the document. And then it's, under the recall statute, the petition cannot exceed 200 words. You have to be relatively brief, you can't put a whole.
Well, they don't want War and Peace in a petition, and no one's gonna read it and sign the petition.
Yeah, but the statute prohibits more than 200 words. And if you submit one more than 200 words, they won't take it, it's about.
Okay, so what's the point?
More importantly, the recall petition statute works. And why it's so important for the dismissal of this case is that this lawsuit was contrary to the operation of the statute. Under the recall statute, Judge, what happens is.
Well, we're not really worried about the recall
Thank you.
process.
Thank
That's
you.
the subject of a different lawsuit, right?
Well, no, I'll tell you what.
So whether or not the petition was valid or invalid, if someone made defamatory statements in it, it's still actionable if it gets over the respective defenses or privileges, right?
Absolutely. I could not disagree more. I think so.
So let's just go back to the example. If we said that in the petition, it said Mr. King's shooting up heroin every night and he's dealing drugs out of his city council chamber. And that's put in a petition, and the petition's 300 words. And since it's over 200 words, that petition technically is invalid. That negates the theoretical defamatory statements made therein.
Two points. The Florida recall statutes, Florida statute 156, less specific grounds, enumerated grounds for the recall petition.
I understand that.
And
But what I'm hearing you say is if somehow the petition is thrown out, that basically defeats their ability to pursue any type of defamatory claim in any form whatsoever. Is that what you're saying?
yes, I'll tell you why. Because the Florida recall statute operates as follows. Under the recall statute, once you gather the 10% of the signatures that agree with this, and the clerk certifies it, they then go to King and Woodson and say, the petition is certified. It says whatever it says about it. You know what? 10% of the voters under the Florida statute sign this, and they support this, and they believe this to be the case.
Well, that's not necessarily true, is it? I mean, people get asked to sign petitions all the time to get things put on the ballot. Some people say, yes, I agree with that, or I don't really know, but if that's something people want to vote on, I'll sign it. Well, right?
If you look at,
I'm still trying to get over the mental hurdle of you saying if somehow the petition's invalidated, that negates their ability to move forward on a claim for defamation.
I it's made very clear.
It hasn't been clear yet.
First of all, the recall petition says, upon signing the petition, you become part of the recall committee. So this
I'll
is
never go
not
back to this
a
again.
case of somebody standing outside Publix or Dixie or Ace Hardware, A&P, I'm aging myself, and signing.
That's more of a northern story, but it was in Georgia when I lived there.
Was signing the petition. In this particular case, by signing the petition, they do two things. They say that if they're becoming part of the recall committee, the same as Veach and Murphy. And second, they're stating they should be recalled with treason. Let's be clear. Everybody who signed this recall petition became part of the committee.
But again, that's wholly irrelevant, isn't it? If she, he, and I all came at you and cut you with a knife, in theory, you could sue all four of us. But you could decide, you know what, I only want to go after Kyle and Fuentes, and, you know, I don't want to go after the other two for whatever reasons, you know. He doesn't have a pot to do his business in, and she's got all her assets in a trust.
I most respectfully disagree.
So I'm not seeing how that undoes the defamatory statements that if your two clients allegedly made defamatory statements and 100 other people or 1,000 other people said, yeah, we agree with that, and the petition's thrown out for whatever reason, it doesn't undo the fact that statements of some kind were made that they contend are defamatory and not protected by some privilege.
Two answers.
Okay.
One, there's a vast difference between stabbing somebody or shooting somebody or punching somebody.
Okay, well, that's a bad analogy, but let's just say in the defamatory context, you say horrible things, and she says horrible things, and he says horrible things.
Oh, you know what? I have every
They can still just decide to sue you or her or him, or you know what? I've been damaged by all three of you saying that, and I'm going to sue all three of you. But just for the fact that other people signed on board doesn't, and they're not pursuing them, doesn't mean they can't go after them, does it?
because maybe they could sue everybody who signed the petition, and maybe they could sue every resident who voted marijuana.
So
So
I
Oh,
used
they
to
didn't.
tell my clients, you can sue anybody you want to with a piece of paper or a pen and a filing fee. It doesn't mean it's valid.
I've submitted, I think it's 6 and 7. You know, there's no dispute about this. There's no dispute about there's no dispute about what myself and my colleagues, what the petition says, what the defense was, it's all on the record, it is movies. So let me just, after as part of the recall process, before it goes on the ballot, Mr. King and Ms. Woodson, or any commission they need, they get to read the petition and draft a defense
They did.
and say, you know what? I disagree with this. This is total BS. This is a lie. This never happened. And then their statement, their defensive statement. Can I have 1 second there? One second.
Or what?
1 second.
Yes, sir.
He's falling apart. He's going back to the recall.
Memorized. I'm just
He should have gone stuck with the anti-slap defense. This is a train wreck for him.
You can keep it if you want.
Yeah, the judge doesn't want your crap anymore.
I'm turning to, if you look at this pink and yellow tab, I'm turning to this.
He's turned to the page, the recall petition and defense counsel member John King. Yes? Okay, go ahead, sir.
If you look, Judge, here's why this is different. Here's why this is different. Here's why this should be discussed. In other words, what was circulated to the 15%, here's what doesn't happen in the streets outside the movement of a recall petition. If somebody goes to Starbucks, I know this is Starbucks, if somebody goes to Starbucks, there's a house. I spent a lot of time with Starbucks. Somebody goes to Starbucks, there's a house, and says, I think this person's corrupt. I think this person's corrupt. I think this person stole money, or whatever it is. What doesn't happen is a following, and it's an important distinction. What doesn't happen in Starbucks is the person I said was corrupt, or a clown, or a thief. I don't get to drag that person and call them up and bring them to Starbucks and stand in front of the person and say, that's not true, I never did that. With regard to the recall petition, Your Honor, here's how the recall petition deals. The Florida legislature in enacting 100.36, they came up with a very clever, very smart statutory mechanism, and that is that if an elected official thinks that the recall petition is slandering them, or is not true, the statute gave them a mechanism. they get to write a statement
No.
line by line. And in this case, the King and Woodson rebuttals, I think, is probably twice the size of the allegation in the petition. So the King and Woodson rebuttals are the same or twice the size of the allegation in the petition that people signed, 1,000 people signed. And the people, the 15% before the recall petition went forward, and here's why this is different. The Florida legislature said the following: wait a second. When the Florida legislature passed Florida Statute 146.1, the legislature said the following: wait a minute. What if somebody circulates a recall petition and the elected official thinks that it's not true, thinks they're being slandered, thinks that these allegations are not true? Well, here's what they can do. They get a chance.
They're doing it right now.
Line rebuttal, and before it goes on the ballot, 15% of the registered voters have to read their rebuttal saying it's not true. So the 15% of the voters who voted to put this on the ballot, not Veach, not Murphy, the 15% of the registered voters,
Getting riled up.
people who voted to put this on
Gonna
the
pop that button.
only did so after being presented with King and Woodson's lengthy rebuttal stating these allegations were not true under the statutory mechanism, which provides a basis for refuting false statements. That's not going to court with defamation. The Florida legislature could have said, you know what, Judge? When the Florida legislature enacted 100.361, they could have said, well, listen, King and Woodson, you know what, or anybody else. If you think the content of the recall petition is false and not true, the legislature could have said, Judge Kyle, you have a remedy. Plan to sue for defamation. The legislature said, we're giving you a statutory mechanism. If you disagree and you think what they're saying is false, write your rebuttal. And this will not go on the ballot unless every single person who read the recall, everybody who read the recall petition circulated by Veach and King and hundreds of other people.
They're not arguing that they lost the recall. They know they lost the recall.
Why they think those statements.
He's litigating the recall again.
The people, 15% of the population, not them, they voted to put it on the ballot, and not only did the clerk certify it, but it went, the chief judge of the district certified the recall election, and it made it to the ballot, and the people voted.
Rest your case, please.
They were both, although both petitions passed by a pretty overwhelming majority, one commissioner was recalled and one was abstained. So in my very humble opinion, I'm going to conclude.
Thank you.
1 minute.
1 minute.
Number one, Your Honor. Here's what they are saying. And this scares, I don't think heck's a bad word, but this scares the heck out of me. And standing here today, there should be a shiver down the spine of every citizen in the state of Florida. I'm going to tell you why. Because here's what they're asking Your Honor. Here is what they are asking Your Honor. They are asking Your Honor to circumvent, render, dilute, and maybe scare any citizen
Oh, come
from
on.
ever circulating a recall petition again. Because notwithstanding the fact that under the statutory mechanism, 100.361, enacted by the legislature. The same legislature that passed the stop statute. The statutory mechanism, the same legislature that passed 768.295, the stop statute. They enacted a statutory mechanism of 1.36 that said, here's how you deal, Judge. Here's how the legislature said you deal with false statements. Here's how you deal, according to the Florida legislature, with concerns that you're being slandered and these allegations are false in the confines of the petition. You write your rebuttal, explaining in great detail why it's false.
In passing that statutory provision or mechanism, as you said, i.e. the ability to respond to statements that you believe are false in a petition like this, did the legislature in their legislative history say this is going to then thus preclude the right to pursue a common law cause of action for slander?
No.
Or libel or anything of the sort for defamation?
They didn't say that, but what I will tell you is that we've been asking your Honor to recount like 1 point.
I thought he was recapping already.
Your Honor to do this. Just call. That's what they have said. They're asking your Honor to rule, in my opinion, in a landmark decision, and say that anybody who circulates a recall, I'm assuming every elected official. I was once a mayor, and I was subject to a recall petition.
Yes, you were.
Came closer than I would like to. But I'm going to tell you this: you're saying, you're asking your Honor to hold in a landmark rule that every single person who complies with their right under Florida law to circulate a recall petition is now going to be subject
To tell the truth.
to the elected officials going to the petition, assuming that was fair. And let me make it clear.
Well, elected officials have to have a thick skin, regardless of the type of elected official. As you indicated from your own experience, hopefully that's the case.
My experience was,
But having said that, you still have a right not to be slandered with malice if you're a public official for that.
Yep.
my view was, if you don't want to be criticized, don't run for office, but that's okay. Otherwise,
It's not about criticism, doofus.
People, but what I would say, Judge, is that here's the problem with lawsuits. If your Honor rules and does not dismiss this case, the message to everybody, not only here, but everybody in Florida, is going to be that if you dare to sign a recall petition, even though they're going to get a rebuttal, a Woodson or King or somebody else can sue you for defamation or slander if they don't have, and let me say this, probably, I can't imagine, Judge, I can't think of a mayor, commissioner, park commissioner, anybody, I can't think of any local public official, Judge, who's going to read a recall petition, just by their very nature. In order to even get the petition certified by the clerk and the chief judge, you have to allege malfeasance or misfeasance. So that means the following: because you have to allege malfeasance or misfeasance, to even get the petition certified, Your Honor, I doubt that there's any public official in foreign history who's been the subject of a recall petition, who didn't want it to be recalled, who didn't think they were being in some way slandered or defamed because they're being accused of malfeasance that they didn't do. So let me say this, right? I can't imagine any local elected official who's accused of malfeasance or misfeasance in office who isn't going to think that he's being somehow generically defamed or slandered by someone. But their remedy to a recall petition is to write their rebuttal. I want to end by, I'm going to tell you my 4 points. The snap statute, then I'm going to sit down. My 4 points are, the one, Your Honor, thank you for your graciousness and your time. We appreciate it.
My time is your time. You need to keep thanking me. So
We appreciate it. We appreciate it.
Come on, you brown noser.
Number one, the completing defect because multiple paragraphs refer to Veach and Murphy as chairs of the committee and doing things as chair of the committee with no individual allegations, not a single individual allegation against Veach or Murphy outside the content of the competition. Second, the language on malice is, they don't do any open fact reading. The language on malice, express malice, is conclusory. It does not come close to reaching the policy. Number three, as I said, you're reading the recall statute out of existence because no one's ever going to see a recall petition again, because every recall petition alleges malfeasance in this case. And every Florida resident going forward is going to be subject to hiring a lawyer. Every plumber, homemaker, everybody who works hard for their families, everybody who's out there fixing cars and working hard for their families, everybody who's going to sign the recall petition saying, you know what, I agree with this. I'm going to become part of the committee. I want to recall them. They're now going to be subject to a standard lawsuit. That can't happen. And finally, I want to quote we mentioned Veach. Unfortunately, I was one of Veach's lawyers at the initial stages before I moved on and he went to the Florida Supreme Court. But I will tell you that having litigated three other cases that were up there for the verification of the Florida Supreme Court, myself and my colleague were quite to brief the Veach decision because we had other cases that were up at the same time. We were all told, what's your view on this? What Veach said was calm, Judge. What Veach said was that some of the cases, including the cases that we cited, said, Your Honor, that if you're petitioned for if you file a slap, if you petition for a slap, if you file a motion to dismiss on the grounds of a slap suit, Judge, they said that if Your Honor denies the motion to dismiss, right, that means that you can file a writ of cert because the denial of the motion to dismiss is an egregious wrong. So it had been hard, it was a split among the circuits. And some of the circuits, Your Honor, had held that the districts, that when you file a slap statute, when you file a motion to dismiss on slap,
He's so lost.
they held that if Your Honor denies it, you're entitled to file a writ of cert because that's an egregious wrong. And Veach held that not every Veach held that you don't get a writ of cert. But what Veach did hold, Your Honor, was the following. The Supreme Court in Veach amended the Florida Rules of Appellate Procedure. So in the Veach case, which was cited by my colleagues and myself, the Florida Supreme Court said as follows. It is so important, the slap statute is so important, and it's so important to protect citizens from being sued for exercising their rights. So the Florida Supreme Court held in line with the language of the Florida statute that this is so important. Judge, they actually in Veach amended the Florida Rules of Appellate Procedure to state that if Your Honor or some other judge denies the motion to dismiss based on the slap statute, that you're entitled to an immediate interlocutory appeal. So in Veach, the Florida Supreme Court amended the Florida Rules of Appellate Procedure terms to now state, and it does state now, that under the Florida Rules of Appellate Procedure after Veach, anyone who goes in front of Your Honor or your fellow judges, if our motion to dismiss like this one on the grounds of the slap statute, if it's denied, then we have a right to an immediate interlocutory appeal. That's how important they gave it. So I want to end by reading the quote. A person or government entity in the state may not file, of course, to be filed through its employees or agents.
You're reading from subsection 3, correct?
Yes.
It's 768.295.
Person or government entity in the state may not file, of course, to be filed through its employees or agents. Any lawsuit, cause of action, claim, cross-claim, or counterclaim against another person or entity without merit, and primarily because such person or entity has exercised the constitutional right of free speech in connection with a publication. And I would note that the Florida statute defines free speech as any written or oral communication under applicable law that is made to a government entity. And I would note that if you look at the beginning of my tab, it's the first thing in it, it goes along the first thing. I cited the Goodell case, I think it was before PCA. And in Goodell, which is the first case in my brief, it was cited. In Goodell, the Florida, the appellate court cited the legislative history of the anti-SLAPP statute in 2010. And the legislative history said, in terms of most of the legislation, quoting the Goodell case, strategic lawsuits against public participation or SLAPPs are typically dismissed as unconstitutional, but not often before the defendants are put to great expense, harassment, and interruption of their duties. These lawsuits are an abuse of the judicial process and are used to censor, intimidate, or punish citizens. And finally, the court said, it is essential in our democracy that the constitutional rights of citizens to participate fully in the process of government be uniformly, consistently, and comprehensively protected and encouraged. If two citizens of the United States in the state of Florida cannot circulate collectively with other citizens or recall petition under the First Amendment or the Constitution, and under a statute that gives them that right, and even gives the elected officials the right of the public. If they cannot do that, then we are reading the recall statute and the SLAPP statute out of existence. And I will end and make a bold statement. You absolutely cannot sue, and I've never heard of any citizens, and I could be wrong all the time, but I'm not familiar with any case where Fort Florida is held. You can sue someone who circulated a recall petition that made it to the ballot. They solely on the content of the petition. They have a right or a statute to do it, and Woodson and King, they have targeted Veach.
Oh, come on.
And through them, every single citizen in their city who exercise their First Amendment rights and their right to grievance against governments. They're targeting all of them by this lawsuit. It's scary. I would ask your honor to end this nightmare for the citizens of Florida, the citizens in their city. I would ask you to dismiss. I would have made two requests. I would ask your honor to dismiss the defamation lawsuit filed against Veach and Murphy. I would ask your court to order King and Woodson to pay all of Veach and Murphy's legal fees. These are specifically directed on the SLAPP statute. If your honor disagrees with me, I would respectfully request that this case be stayed so that we can pursue an interlocutory appeal, which was specifically the direction given by the Florida Supreme Court.
1 hour and 10 minutes of gobbledygook. Now, the judge might dismiss this today, but it's not going to be because of him. It's because the bar is very high. Hopefully he'll speak up.
I could kind of go and essentially
decisions in regards to a similar circumstance or situation?
Not as a recall statute, no, but the initial version of that statement that people exercise their right to redress and petition the government has never been subject of an action. That's not true. NODAR itself was. NODAR itself was based on a school board in which someone allegedly disabused a public high school teacher, allegedly defaming the state at the school board meeting. So that there's one. The second part of that is the substatute itself requires, in order for the statute to apply, it has to be made, it has to be a statement made to a governmental entity. And that section 768.295(2)(a) defines that free speech in connection with public issues means written or oral communication. That
Any written or oral statement that is protected under applicable law and is made before a governmental entity in connection with an issue under consideration or review by a governmental entity, or is made in connection with a play, movie, television program, radio broadcast, audiovisual work, book, magazine, article, musical work, news report, or other similar work.
Right. We don't mean that after the or, I'm focused on before the or. It actually applies to governmental statements or government's made to the statement. So to answer your question directly, no, there's no case that talks about a recall statute. That part is true. But the idea that this isn't contemplated, it's actually part of the definition is in order for the statute to apply, one part of it is it has to have been made while addressing a government. So the idea, this is, I guess, kind of the big picture here, is the concept being made here
In context of what, a public hearing?
any addressing. So yes, public hearing was no power, that was common, but it would be anything. So it would be any written or oral statement that is protected under local law, which we get to this one is protected, and is made before a governmental entity in connection with an issue under consideration or review by a governmental entity. 3. So there's an argument to be made that the slap statute doesn't apply to the recall petition at all because it doesn't meet that definition. I'm not arguing that today. I think that's silly. I mean, it's contemplated that this is, I don't disagree that this is a recall petition is an exercise of your duty. But that leads us to the big picture is the concept that's being argued to the court is that if you exercise your First Amendment right to petition your government, that there is never an avenue to defamation. And the case law is absolutely legion. That's not true. We wouldn't have New York Times versus Sullivan if that were true. What we have is, and I think the court sort of touched on it, is yes, public officials have to have thick skin. No question about it. But they don't give up their right to sue people for defamation. They just have a higher penalty. So they have to prove actual knowledge of the truth or reckless disregard of malice. They have to prove that. They also
By
have
clear and convincing evidence.
by clear and convincing evidence, also true. So they have
It's a high burden for your clients to meet, is it not?
Mm-hmm.
absolutely, which is why the Supreme Court over the course of the last, whatever it's been now since 60 years now, has fashioned this gate around the public arena is, but by definition, what the flip side of that is, you still have the right. You just have a much higher hill to climb in order to exercise that right. Otherwise, they would just say, if you make a statement in that witness stand, it isn't you. And I'm going to get to Merrider in a second, because Merrider addressed that issue.
That's a different issue, but I
It is.
get what you're saying.
It's not immunity, it's a higher burden, absolutely true. And we have to prove all that, that's our burden. But the cause of action exists, and that's what we're here. We're here on the cause of action. So let me just.
So the legislature didn't negate that by providing for an opportunity to give a rebuttal statement in a subsequent petition that would need to be re-signed.
Well, let me talk about
That's
that.
effectively what he was kind of arguing in court.
It is what he's arguing, and technically it doesn't get re-signed. The 10% original, and 15%, those aren't the same people. They can be, but they're not necessarily. They don't go back to the 10 that signed the first one and say, here's their
rebuttal.
any 15% of the registered voters.
Right.
But they have to have that percentage signing the petition with the original language and then the rebuttal, correct?
Absolutely. And, because to take away a bunch of common law rights, it's not just defamation, it could be whatever, it might be interference, intentional interference with contractual relations, it might be a host of other things. Conceivably, I suppose, a contract, can't think of an example now, but all the rights, what you're asking to explicitly read into a statute that is dead silent, something as extreme as saying, and by the way, by doing this, we are also negating all other causes of action that might arise as a result of the competition. It's not in the legislative history, it's correct, and it's certainly not the statute. So we don't read into this. It's like the legislative exclusion, and you probably had cases like this. Does a statute occupy the field? So we don't have express exclusion. Sorry, take that back. You have to have express exclusion, or it's not excluded by statute, or the statute has to so occupy the field that it is explicitly expressly excluded. Very, very rare does that happen. That's essentially, we're not anywhere near that standard. It doesn't even talk about what he's suggesting. So I think that would be a slippery slope. So let's start at the bottom, which is the pleadings. And then kind of the way we look at it is this. If you have a basic garden variety defamation claim, and it has elements in it, and we're going to address that. I know it makes you nervous.
It's his whistle, it's time for him to go. He starts early in the day.
So you got basic garden variety defamation, those are the elements. And then on top of that, if you have a defendant, you get a little bit higher wall. If you have a public official, you have a little bit higher wall. And in the context of a statement that's made petition of a government, you have the SLAPP statute. So I'm going to address all three as we go up about it. But let's start with what the elements are, because the last three things I said have nothing to do with the elements. Those are privileges and defenses to the underlying claim. So the underlying claim is, was there a false statement made with reckless disregard of actual knowledge or reckless disregard of the truth? And we say those magic words. And I would agree with Mr. Peasy that the current state of the law is that merely reciting verbatim the magic words is not sufficient. I agree with that.
You can't just use the buzzwords, but did you do more than that? He says you didn't even use all the buzzwords.
We use all the buzzwords. I'll read them to you. So starting with
Other than the, I think it's an adverb, my English professor would be mad, but other than you say they maliciously,
mendacious.
well, you said mendacious, but you said, where is it? In paragraph 13, Mr. Veach maliciously published. Did you use the word malice anywhere else in the context of the alleged defamation being caused? Or,
Yes, we actually give the facts that constitute the actual malice standard in paragraphs 9, 10, and 11. So what we do is in paragraph 9, we say the magic words. We say, quote, several of the allegations in this petition are categorically false, were made with intent and knowledge of their falsity, and or were in utter disregard of the truth thereof. Yes, those are magic words, but those are also the very
is utter disregard the same as reckless disregard? Because the case law uses reckless.
Good point. No,
Okay.
but we don't. I feel like I'm wrong. But wait, there's more. Paragraph 10, though, we do go on and we say that Mr. Veach published, and we say the same about Mr. Murphy, published the King petition to members of the community with the intent of tarnishing Mr. King's reputation and having him removed from office based on false allegations and lies. That is a specific case, certain allegations, not just magic words. We go on to say Mr. Veach has a personal vendetta against Mr. King, and thus spread, this is the reason behind it, thus spread those brazen and insolent lies with the sole purpose of harming Mr. King's good name, reputation, and position as a counselor. Those are all specific facts, which, if true, in our case, if false, we lose our case. So this is what this case is going to be about: is did Mr. Veach do those things with the intent of tarnishing his reputation? They might prove otherwise. They might prove no, and I lose.
Right, if they prove some other purpose, they win.
If it overcomes the utter disregard,
Well,
reckless
you
disregard.
said the sole purpose was to harm the reputation and name, so if they prove some other purpose, do they win?
Arguably, yes.
Okay.
Yeah, because that's part of the the reckless disregard standard. And yes, it is possible, and that's true, forget about the slap cases, that's true of defamation generally.
So what if their primary motive was just to get them out of office because they didn't like them, as opposed to harming their reputation?
Well, that would
You lose that.
that would negate the law. That can still be underlying.
But for malice, that has to be the primary purpose, doesn't it not?
Why, I said, I know it's
Now, the primary purpose would be to injure the plaintiff.
and have it removed from office based on that. So I understand your question, and if we change the analogy a little bit to say if it was something other than that, I'd probably agree with you, but it did, as to your analogy, it did actually lead down there. And we think that is the case, and we're gonna prove that in this case. But it goes on, because
By clear and convincing evidence, what evidence do you have? I know you don't have some yet because you've not done much discovery.
well, actually, we do have quite a bit.
But when you file suit, you're supposed to have bird in the hand and ready to go in theory. So what evidence do you have that's clear and convincing in that regard?
So,
I'm not asking you to pre-try your case per se.
it's okay. So we were made up, there were very specific allegations that were made in
Petition.
the petition. And
Because he's asking you just to throw it out outright. Do you agree that the court has the authority to do that or the ability to do that under the current circumstances?
only under the slap statute, which, and the answer to the question, we know in this state, because the slap statute, we would have affidavits that show the need, so the burden shifts, right? So yes, there are walls on our side, actual malice, reckless disregard. But there were risks that our claim for defamation was without merit.
I'll talk to him later. Go ahead. His boss is taking his phone. Go ahead.
So they have to prove their,
I chastised everybody about phones and yours went off, so I had to say something. I apologize. Go ahead, sir. I'm sorry to interrupt you.
it's okay, he's got a taser.
That's right. We're all scared of him.
But the burden on their side is that they have to prove, one, that we did it without merit, that our claim has no merit. So that's their burden. The second element that they have to prove is it was done solely for the purpose of attacking the free speech. So those are the two elements they have to prove. So under the case law, it talks about the process under the slap statute. Yes, you can consider affidavits. In fact, Judge the county had that same case where the site didn't produce any affidavits, and so the slap statute that supporting.
Are you involved in my other slap statute with all the congressional people? No? Okay.
So,
I had an army of lawyers in that one, and I didn't know you were one of them. They were all over the map. It's irrelevant where they're from, though.
that's right. So, but the idea is that yes, you can consider those affidavits. The second CCA in the case that came, not your case, but the other case, said that, and that's fine. So there are affidavits submitted in the record. You have them in my book. Problem is, they don't actually go to the elements that are their burden. They don't say our claim is made is without merit. They don't actually even deny the falsity of the claims made. What they do, they don't deny the falsity of what we say are the lies. They don't even deny whether they were made with malice or not. All they say, and they're in my tab, by the way, Your Honor, if you're looking for the my notebook, they are at tabs 4 and 5. And what they say is they just reiterate that the claims were made, and I'm just quoting, the claims asserted against me, this is Mr. Murphy's affidavit. The claims asserted against me arise entirely from my participation in the recall process authorized under Florida law. Then it goes on to talk about the recall process. Not once does it say the statements I made were true, the statements I made were based on X, Y, and Z, the statements I made were made not for the purpose of malicious intent. It doesn't say that. All it says is that they were co-mingling our allegations and we had vague and allegation essentially repeats the motion to dismiss. So under the SLAP process, you would deny the motion to dismiss because they haven't carried their burden of proof under this expedited process of pointing out that there is something that our claims are without merit and made for the sole specific reason of acting with protected speech, which will lead us to the protected speech part in a second. We're going to get to that, but it's not protected speech anyway. But we don't have to get there because they haven't met their initial burden at the motion to dismiss stage, and you are absolutely within your rights to deny the motion and move on. So that answers your question, by the way.
Yes, sir.
So the other, the pleading defects, so back to the pleadings, is we then go on to talk about what the identified statements were, and this is really what comes up a lot in defamation cases, is maybe the statement isn't specific enough that so-and-so might have heard somebody say something on Facebook. By the time the telephone game gets back to the first 2 years, it's not a statement, it's more of a feeling. So we in paragraph 11 actually call out the statements, and we say, Mr. Veach, again, you can say perfectly, but this is an example. 1, falsely states that Mr. King, 1, engaged in private conversations to coordinate with council member Karen Woodson, soliciting a replacement town attorney, period. That's false. And how do we know that's false? Because we've got Mr. King and Ms. Woodson. We know they didn't talk to each other. And we also know that there's no evidence that they have to show that they ever talked to each other to coordinate in private conversations, to coordinate with each other to solicit a replacement town attorney.
And why is that a form of defamation or libel or slander, if you will? Is that because those types of private conversations would in essence be a violation of the Sunshine Statute?
Yes, which is a criminal statute. Even though when it's prosecuted, it does have a.
You haven't alleged that though, have you?
No, don't do I for a complaint. That's more than one complaint. I could, but that is why that is in there. Number 2, you're going to ask the same question because.
Well, but the only reason why I ask is your average person might not necessarily know that 2 elected officials aren't supposed to have a private conversation about policy and procedure
Oh,
and
they
things of
know.
that sort.
Also true, which goes to whether we get to a summary judgment stage, or these reasonably conceived to be defamatory statements, and the answer in that statement would be yes, but I understand the point. And I will admit that the court would prefer to see that in there because it applies to all 3. So number 2 is the same thing, but a different statute that's violated. Received unreported gifts of meals from parties who were seeking land use approvals from the town council. Now, this was a little bit.
What's that supposed to be, bribery?
Bribery, right, but also a chapter 112 violation, as you know, because I think, judges have to fill out.
Everybody has to report gifts of a certain type of amount, et cetera.
Right, and so if we took out the word unreported, then it'd just be the bribery part. But there's actually 2. One is received unreported gifts of meals from parties who are seeking land use approvals from town council. 1 is receiving gifts of bribery. Unreported gifts is a violation of chapter 112. And that's also, there's a criminal component to that. And exercise there. And then, of course, we have the 3rd one, which is malfeasance or malfeasance, which ironically is defamation per se, because defaming someone or disparaging someone in their job is actually defamation per se. So you have loathsome disease, criminal conduct, and disparaging someone at their job is actually defamation per se. So all 3 meet those elements. I would agree as to number 1, if we could clarify, but I submit for where we are today, it would be necessary. So that's the baseline. That's just if they were non-commissioners, if we didn't have a SLAP statute, that'd be the baseline argument. And we would say we've met it, or possibly we could address the issues addressed. Now we move up to the next one, which is the mountains. So we did go into your prior question. We did say the magic word. We did put meat on those bones and we're explaining it and what they did, what specifically they said. So the motive behind it, what they said, and that it was done maliciously. And then I agree that the statement that Mr. Veach has been invited on multiple occasions to present evidence to support these lies. He is not and cannot, as allegations are wholly based on falsehood. I agree that it's an irrelevant statement in and of itself, but it also goes to that evidence of picture a trial, Your Honor. Picture a trial. And Mr. Veach is on the stand, and he talks about these statements and that he has this bona fide good faith belief that these statements are true. I'm going to get up on cross-examination and ask him a whole bunch of questions. I'm going to be, did you ever talk to the town attorney? Did you ever to the target of this? Did you ever ask him? Did these two folks come in together and talk to you? No. Did you ever talk to anybody who allegedly bribed them, the giver of the money? You ever see them get money? Did you ever talk to the person who gave them the money, bought them gifts, whatever it is? No. And unlike a lot of things withdraws is, here's going to be a whole bunch of emails where you're asked to review these. And as you know, silence in the face of the point at which you should speak can be circumstantial evidence. It's not direct evidence, I acknowledge that.
You think silence is acquiescence?
Silence is acquiescence, yes. And if someone says, you're lying because you don't have it proved, a normal person would respond with, oh, yes, I do. I talked to Mary or Bob or Jane, and they saw you take the bag from Defamation, whatever. None of that happened. So we think it's all there, sufficient to meet that allegation. So now let's talk about the SLAPP statute. The SLAPP statute is not, and this is the core difference between our positions.
Again, 768.295. Go ahead.
Yes, 768.295. The SLAPP statute is not, the way it's described here would operate as legislative immunity. A congressman can get up on the floors of Congress and say pretty much whatever they want, unless it's treasonous. So even that has limits, but or sedition. But even that has limits. But mostly, for the most part, you can say whatever you want. Legislative immunity, testimonial immunity. There's qualified immunity that attaches to some law enforcement activities. This statute is not an immunity statute, full stop in this story. And how do we know that? Because Justice Groves told us that in her 406 Southern 3rd, 945, which is actually page 4 that was printed, and that's a tab 11. The argument made there by Powell, in that case, it was American Powell. Powell, in that case, was making that same argument that Mr. PT is making here, which is that the statute provided immunity from suit. And what Justice Groves said in response to that, and I quote kind of the third paragraph down on the left, is though we do not share Powell's narrow view of the statute, we agree that the statute does not provide traditional immunity from suit. In coming to this conclusion, we focus on the statute's text, noting how it differs from other branches of statutes and cites a case that I won't cite. And then the next paragraph starts with, quote, Florida's anti-SLAPP statute does not use the word immunity or words with comparable meaning. And it cites back to 768.295. Quote, this stands in contrast with statutes that expressly confer some form of immunity, and those are the ones that just talk about law enforcement immunity, immunity, workers' comp immunity, arbitrator immunity, the whole bunch. And this is not one of them. So what does that lead to? It leads to the next paragraph, and I'm going to just bear with me. I'm going to quote a lot here. It says,
The upper right corner.
yes, sir. So it
Did
starts,
you give them a copy of this too, by the way?
I did.
You gave me a highlighted version and whatnot, so,
I did.
okay.
I did. Do you like them highlighted?
Well, I prefer it, because when I'm looking through in preparation for hearing, it helps call my attention to what you think is important.
Good. I'm going to back up.
But the reason why I ask is you're obligated to give him identical copies, same highlighting, same everything. And unfortunately, sometimes I get some attorneys that give the judge a copy that's highlighted, but don't give the opposing counsel an equal copy. So that's why I asked.
They don't give copies at all. But
That's true too.
But what it says is, quote, nor does the statute contain structural or textual clues that might support an absolute right to be free from litigation. Then to the highlighted part. The anti-SLAPP statute, in fact, suggests that a successful anti-SLAPP claimant will endure some level of litigation. To prevail on an anti-SLAPP claim, the defendant must show that the plaintiff's lawsuit is without merit and brought primarily because the defendant exercised protected free speech or conduct. A judicial determination that a speech-targeted lawsuit is without merit may not be possible at the outset of a case and may require the development of a factual record. The anti-SLAPP statute also specifically notes that aggrieved parties will have to avail themselves of standard litigation features such as case dispositive motions and hearings if they are to benefit from the statute. And then they go on. So the next paragraph, though, goes to Mr. Pizzi's quote. Absent the benefit of any claimed statutory immunity, Barracker can only point to hardships typically associated with continued litigation. But we have repeatedly held that this sort of burden does not constitute irreparable harm in ordinary circumstances.
Well, the remedy would be, ultimately, if you prevail, you might be able to recover your attorney's fees in the face of a bad claim, right?
Right. That's
The monetary judgment is reparable harm, I suppose.
right. Exactly. And that's the hammer that. So there's. But take a step back and sort of intellectual big picture. Is what you have, and you have these competing public. I'll talk about the Tiger case, which is the just the. I think what's the word? This is the Queen Baskin case. Baskin was Carol Baskin, and Tiger King name, and she published, I guess, a podcast where she made all kinds of allegations about the family of her Mr. Lewis, a personal assistant whose remains are unknown to this day. For anyone who watched the special,
Is that the missing husband of hers?
missing assistant.
Oh, assistant. I thought it was the husband.
Yeah, I was thinking the husband in jail or the. I don't know.
No, Tiger King's in prison.
I'm going to defer.
You can look it up later.
Yeah, right. So yeah, someone's missing, and I think they got eaten by the tiger. So she goes on her podcast, makes a whole bunch of allegedly defamatory statements, gets sued, and then she raises 768.295 and says, anti-SLAPP. I am a public person. I'm in the public eye. You are subject to this higher standard, and I am simply making statements that are constitutionally protected free speech. In the second DCA, actually the trial court agreed with her. So this was up in Tampa. And the second DCA reversed because what they said is, quote, actual defamation, however, is not constitutionally protected speech, end quote. And they cited the 5 elements, which I went over: publication of a false statement with knowledge or reckless disregard of the falsity, which causes actual damage and is defamatory. Those are the 5 elements. And they looked to the statute 768.295 and talked about the definition that I read earlier, which is it has to be speech that is protected speech. So if your SLAPP statute protects protected speech, and the second DCA just rejected that. It said actual defamation is not protected speech. Went on to quote the, and I'll just give you the site for the records, Queen v. Baskin 377 Southern 3rd, and that is at 176. Court went on to quote a 5th DCA case, which is called Fox v. Hampton at Metro West Condo. Quote, freedom of speech does not extend to obscenity, defamation, fraud, incitement, and true theft, and speech and real conduct. And so we know that it's not actual speech. But the issue before the court is how to balance these competing interests. And so on the one hand, you have the right to petition your government, the First Amendment. But as I discussed earlier, we already know there's no per se bar to defamation in the context of exercising the First Amendment rights. That's just not true. We have lots and lots of arguments But beneath all that is a right defamation in the context of personal speech. And so you look at this statute and you say, okay, is this constitutionally protected speech or not? And the answer is from Baskin. The answer is in all those cases that they cited. And the answer is no. So at the stage that we're at, this ties back to Barron, is at the stage we're at, if there is actionable defamation as pled in this lawsuit, the anti-SLAPP statute cannot be adjudicated at this point because there are no affidavits that say that it's without merit or done only to attack the protected speech. And if there were, we have counter affidavits that has
6 or 7.
yes,
6 and 7. 7 are the affidavits.
yes, and they go into some detail, and they're different. Ms. Woodson is actually a bit longer, and names, talks about whether or not she talked with, for instance, Vice Mayor Dave Emerald, Jim Emerald, about the Lee County Pier. She goes on to other issues outside the scope, but talks about the issues inside the scope, and affirmatively addresses it with detail. Mr. King does the same thing, but a bit more directly in the sense of proving the negative. Think about it. Someone accuses you of having a private conversation other than saying that never happened. It's a little hard to have affirmative facts. I suppose at some point you get a travel ledger out, see who's even at the state at the time of the alleged meetings, that sort of thing. But at the outset, it's really just disproving the negative. Now I want to talk about something go back to this recall petition as a washing the slate. And I want to use your heroin example. And I'm going to use both ways, whether it's a valid petition or an invalid petition. So you use the example of it has 300 words, it's invalid, and therefore it's not out. I'm going to use both. Is if I say,
Well, I don't know if it's thrown out or not. That's a different court on a different day, and you all had a different lawsuit over that. That's what he was saying. If it's over 200, it's invalid.
Yeah.
But his argument essentially was if the petition was invalid, that somehow negated the defamatory statements you contend were contained therein.
yes, and I would agree with the court that I don't think it makes a difference whether it is invalidated or not. So I'm just not going to dispense with both examples. I don't think it matters. I think if you make a statement in the context of petitioning your government, and it is defamatory, so it is actually, now whether you can carry that burden or whether they have affidavits, because it's an expedited process for the SLAPP process. If they had affidavits that said, here's a picture of John King snorting heroin, shooting heroin, then a SLAPP statute would apply, would be done because my case is with merit. That's not what's happened here. He's just saying the SLAPP statute's out there and therefore you have to dismiss the lawsuit. And that's not what Barron says. What Barron says is you have to go through some process in order to get to the two things that they have to prove, which is wholly without merit and done for that specific purpose of attacking the speech. But I'll use the heroin example. If someone is presented with a petition that says John King shoots heroin at the committee meeting or the commission meeting, and he's given the petition and he says, I've never shot heroin at a commission meeting, and 15% of the people say, well, I don't know what's true or what's not true, I'm going to put this on the ballot. Remember, that doesn't go on the ballot. The only thing that goes on the ballot is should John King be recalled or not. So the whole rebuttal argument sort of dies because it doesn't really go to the voters. But leave that aside, is if I say that.
So that's only seen by the people that sign within that 15 percentile.
Yeah. Okay. So, but if I say that, that doesn't mean that the defamatory statement was made. Pure and simple. And so whether it's valid or invalid petition, that makes no difference at all. Whether the voters approved it or didn't, doesn't have anything to do with whether there was a defamatory statement made. What it does do is it raises a vehicle by which they can prove through affidavits at this stage, later through testimony, that our petition was made wholly without merit and for the sole purpose of attacking protected speech. We'd argue the protected speech part is lose, I think. But I can be wrong. I think you could say, look, I hear you, but I don't think it's defamatory, and so it is protected speech, and it will apply. that's what they have to prove, and it's expedited, and that's what protects them from undue litigation. That's as simple as it is. It's really that simple. There's a baseline defamation lawsuit, and the question is, what's the process for processing that lawsuit? And right now, we know what that process is. They're burden to show without merit for a particular sole cause. They haven't done it. Motion should be denied.
Any questions? Yes, sir. Anything else? Response?
A few points, Judge. I'm not going to use it very much. I think I've made all my arguments. Let me just simply rebut some of the things my colleague said.
Okay. Why don't you go to the podium if you wouldn't mind, and that way they can see you and hear you a little bit better in the gallery.
Thank you.
Just turn the mic too, would be great.
Number one, Your Honor, point to something which confirmed by my colleague here. And it is that Mr. King and Ms. Woodson was not removed by Mr. Veach and Mr. Murphy. She was removed by the voters. The voters saw on the ballot that recall Woodson. We don't remember that. The petition and Murphy and Veach should recall Woodson. Woodson was recalled by the people who voted to recall Woodson. And Mr. King, the people who voted to recall Mr. King, which is one overwhelming majority, the petition was tossed. Those people who, majority of the voters voted to recall King. So the people who voted overwhelmingly to recall Woodson and King were their own voters. People certainly think there's a rebuttal number two. I think that, in the political context, there's nothing unusual about various forms of immunity. Obviously, the sovereign immunity. Obviously, there's litigation immunity. You can't be sued. You may get sanctioned by the Florida bar or held in contempt by a judge like the government, but you can't be sued for defamation in Florida. They get tossed out. You lose your license. You won't be. You can't be sued for defamation in Florida under the litigation privilege. And finally, if you want to be in the purely political context, legislative immunity. Legislative immunity in Florida is overwhelming. Reality a legislator in a lawsuit on the dais initially. If Mr. King or Ms. Woodson or any other person is on the dais and they want to say, this person, we should fire the parks director because the parks director is a convicted vagabond. The reality is those public officials have absolute legislative immunity. Whatever statement they made, even if it's false. Rebuttal number rebutting and bringing something by common sense. Your Honor asked what I said in my remarks was that, and I'm glad I wasn't proved a liar, but I said in my remarks, Your Honor, was that I'm unaware of any case in Florida history. I'm unaware of any case in Florida history where someone has been sued for defamation based upon something circulated in a recall petition. And I stated that if the court did not dismiss this case, there would be a horrible precedent set in the state of Florida where this would be the first case in history when people were sued for defamation because they circulated the recall petition and the public officials who were recalled said it was false. And my colleague, I think you can read the lines, you can read the cases.
Well, it's a little more than that. It's not just false. They're saying it's defamatory, right? Okay.
This will be the first case in Florida history where we both agree that neither myself nor my colleague, spending a lot of time getting ready for this, have found any case in Florida history where people were sued circulating a recall petition where people pretending it was false in the fact that this would be first. So there's no disagreement that if the court would not dismiss this, there would be a precedent that politicians who are recall or subject to recall petitions, people in the city, could sue people who did nothing more than circulated recall petitions that they claimed. Number three, I would point out that the 15%, the people who voted didn't see the language. They're not suing them, as my colleague has just stated now. They're not suing them because they held a press conference. If you look at the four corners of the complaint, they are not contending, Judge. They are not contending with the explicit, Judge. They are not contending that Veach and Murphy, aside from circulating the recall petition, held a press conference or went on TV or went on Fox News or CNN and made a bunch of accusations. They're not saying that they went on CNN or went on the Sunday talk shows, Meet the Press or whatever, and said, you know what, these people, whatever they're going to say, the sole and exclusive allegation against them is they're claiming that the language of the recall petition that they're circulating.
No,
Next,
But the defamatory
Nope.
published to third parties, whether or not it's on television nightly news and it's broadcast to 50 million people across the country, or it's a neighborhood scuttlebutt and someone saying the next door neighbor's running a house of prostitution and a drug den and only two other people happen to overhear it. That's defamation, as long as it's false, it's defamatory, and it's published to third parties, and there's some damage. And it might affect the level of damages if two people hear it versus 50 million, but it's still defamation, isn't it, regardless of whether or not it's a public spectacle or not.
if you plead the standard actual analysis, express malice under the federal constitution, the Florida, the Nevada case, and if your primary motive is not to punish people for engaging in political speech, so it's not
Political speech.
There's a distinction between, there's a major distinction between a false statement and actionable defamation. Even a false statement is not actionable, especially in political context, unless you can prove express and actual malice. And, you know, after in terms of rebuttal, my colleague, Mr. Bradley, talked about, there might be an argument that the SNAP statute doesn't even apply here. The SNAP statute says, quote, because such a person expressed his constitutional right to free speech, and then it also says, quote, before a government entity. So I would respectfully suggest that submitting petitions to a government entity under the First Amendment is a false.
So, again, I think before a government entity means you show up to the school board and they have open public comment and someone comes in and says something before the school board. I think he's kind of conceded the actual presentation of these petitions to the government would probably be protected. But before you get to that point of presentation, you've presented it to 10% of the populace, if not more, because some people I'm sure said, I'm not signing that, but at least 10% of the people saw that statement. And then 15+% potentially saw that statement again, albeit with the rebuttal underneath. That's not before the government, is it?
No, yes, it is. The answer is they
How so?
because the whole purpose of the petition, these petitions are presented to the government. So
That's different, Joe.
So the petitions are all submitted to the government, so I would say that I don't think it's a big leap to say that circulating recall petitions to go and submit it to the clerk's office, getting letters to go to the school board meeting. If I walk around and get petitions saying, I think this principal should be fired because he was doing something nefarious, and they circulate the petition for the purpose of bringing it in front of the school board and submit it to the school board, I would respectfully disagree and state that that is petitioning government. I would note that here, in paragraphs talk about purposes. Paragraph 10 of the lawsuit specifically says that he wanted to tarnish King's reputation and have him removed from office. And paragraph 22 makes it clear that Mr. Murphy wanted to have Ms. Woodson in office. And I think the whole lawsuit, there's clearly the whole recall petition. So it's never been, one thing we're not disputing is that the whole purpose of the recall petition process was to remove people from office. So, I mean, the one thing that makes this case.
You all agree on something at least?
Yeah.
Okay.
I thought small things. The one thing I would say, Judge, is that I think that makes this case easy for me, in my opinion. Here's why this makes this case easy for me. I've heard of it. Is because what I'm dealing with here is people accused of making false statements in a petition they were circulating under a statute to recall public officials. So what I'm saying is, I don't know how you can ever, that's like saying, let me make it, I don't see how you can ever get past the malice standard in terms of people's purpose. When what they did was a political act, what they did was circulate recall petitions.
Well, you can just tell the truth. That's how you get around it.
And there's a reason that, there's a reason, so I don't see how you could ever say Veach and Murphy had actual or express malice and their main intent was slander. When by the very definition of what they're being accused of doing, the very definition of why they're being sued is for engaging in a lawful political process of circulating recall petitions. And the whole purpose of recall.
It's definitely lawful and it has a valid purpose, but I think their position is you abuse the process or the purpose by making, from their position, I don't know if it's true or not, but from their position, categorically false statements were used in promulgating that position. Statements that impugned criminal conduct on their part, which is defamation per se, is it not? If it were just Joe Q, public average person and not a public figure.
Well, their affidavit state that their only purpose was political, was to remove them from office, that they didn't have any office. And there's no.
But don't you have to look at the circumstances? Because from what I gather from the affidavits, there's clearly some, again, I don't know what it is, some personal animus between your clients and these folks over here. For whatever reason.
You know what, Judge? We're going to start suing for defamation. Every Republican and Democrat and Independent criticizing each other. And
Oh, brother, here we go again.
I'm quite sure people who serve on local political bodies or national political bodies in Congress and Fort Myers Beach and Sarasota, I'm sure there's a whole lot of animus among the different political factions. Every city commission I'm aware of has 2 people on one side, 3 people on the other side. I'm sure there's a ton of animus, but they don't go around suing each other. But I would note 2 final things, Judge, and that is that number one, as you pointed out earlier, this is kind of a bare bones lawsuit. They've got to overcome a whole bunch of hurdles to get past the motion to dismiss. Therefore, if you look at the lawsuit, it's paragraphs 1 through 5. Paragraphs 1 through 2 of the complaint, Judge. Paragraphs 1 through 5 state the people's names and the sum is more than $50,000. The only other preceding paragraph before they get to the counts says Lee County is the venue. So paragraph 1 through 5 name the parties. Paragraph 6, the only other paragraph before they get to the counts.
Let me ask you this, because you just brought the point up. So you just brought the point up, so let me ask this. You brought up the fact that this is an action in excess of 50,000. That would be each claimant making a claim in excess of 50,000, correct?
Correct.
Should I send Mr. King's lawsuit to county court or small claims? Because his affidavit says his damages are 2,500.
You could,
Or is he asking for additional damages to his reputation above and beyond the 25?
well, that was a theory. And that, all we have right now, based on that, might bounce back to you if during discovery we get more damage. But yes, your question, answer to your question is yes, you could based on the status of the affidavits now. But of course, in a normal motion to dismiss, you would be looking at affidavits. Your affidavits are to the purpose of
Right.
slap statute.
And the other thing I want to do is, you know, whatever damage may occur, the damage is by the, Wisdom's case, the damages, Wisdom's case, it's damages by her own constituents who voted on the land side of the building, because the two-mile office. She's not suing him. And we talked to Mr. King, he alleges that his damages were $1,000.
2,500.
So, finally, I think that this, my colleague mentioned, you know, what do we determine the trial? You don't,
Isn't malice a question of fact for the jury ultimately? Or are you aware of case law that allows for the court to make the determination of malice or the sufficiency thereof on a record on summary judgment under 1.510?
I think that my experience with defamation cases, I think that at this stage of the proceeding, whether or not they reflect malice is,
The sufficiency of the pleadings is clearly a court question at this juncture. But ultimately, as the case develops, if we get beyond this point, won't that ultimately be a question of fact for the jury, whether or not they can deduce malice either from direct or from circumstantial evidence,
well,
given the
obviously,
circumstances of whatever their situation was?
the answer is no. Obviously, we all agree that in terms of, for today's purposes, whether they reflect malice, try to execute those on. I don't necessarily agree that malice is a jury question on summary judgment. I think malice would be a legal question on summary judgment. In my experience, also, I would note defamation cases, Judge, especially when you give figures, which court really plays initially, and even at summary judgment stage, very important gatekeeper. Because people, you know, we don't want,
Well, that's the whole purpose of the slap statute, isn't it?
yeah, we don't want judges to follow, and I think that, I know that when I quoted the, end of this quote, in a nutshell, and that is, one, is just, my colleagues are asking your honor to be the first judge to rule that citizens who circulate a recall petition that was certified and went to the, where the 15% read the rebuttal. So, two final points. Number one, my colleagues, and especially Mr. King, are asking your honor to be the first court in Florida to rule that where people are accused of only and exclusively acting in the capacity of serving as part of a recall committee of citizens, and where the people who sought to be recalled submitted a rebuttal that was read by all 15% that joined the recall, where they are only alleged to be participating in a recall committee of citizens. And everybody who signed the petition joined the committee, and everybody who signed the petition as part of the 15% read their rebuttal and made a decision. Thousands of people to go forward. In those circumstances, they're asking their honor to be the first judge in Florida to hold that case does not get dismissed, and these citizens who were accused of participating in the recall process are gonna have to spend money on lawyers and all that stuff. And I will end with one quote, and sit down after we vote. This is in the Bell case. Slaps are typically dismissed as unconstitutional, but not before the defendants are put to great expense, harassment, and interruption of interviews. These lawsuits are an abuse of the judicial process, are used to censor, intimidate, or punish citizens. On behalf of Mr. Veach, and Mr. Murphy, I am participating as part of the recall committee. They have an absolute right to do it on the Florida statute and the Constitution. I ask Your Honor to end today the abuse, the harassment, and the intimidation they've been going through for months because they exercise their free speech rights. If for some reason, Your Honor is not on my request to dismiss the case today, or dismiss the case after we contemplate If Your Honor does not do that, I would ask that the case be stayed so we can pursue it in the docket of the appeal, because that was the Supreme Court's direction in America. And I want to thank you for your time. You've been very generous and great.
Thank you, sir. His position is you're creating a slippery slope and you're stifling free speech. Tell me why he's wrong. You're not looking to sue everybody that signed that petition, are you?
Go back to my, oh yeah, what I was gonna say is no, we're not, and I was thinking that why he was saying that, is this idea that, everybody who signs a petition, and it was said a number of times, said, we're gonna strike fear into people who are outside Publix and sign a petition, which I've done, I'm sure that everyone's and stuff. But we're not suing any of those people. Number one, we're not suing any of those people. What we're suing are the people who wrote the petition with full knowledge, in our view, or at least reckless disregard of the truth or falsity of those statements. That's who we're suing, Mr. Murphy and Mr. Veach. They wrote the petitions, their name is all over it, and they're the ones that wrote it. By the way, we didn't just sue them as chair. I said that a couple times. It's a defined term in the complaint. So on page 1, it's Mr. Veach and Mr. Murphy individually and as chair of the committee recall, quote, Mr. Murphy and Mr. Veach respectively. So they are defined as wearing two hats. That's how
They weren't even defined. I think the petition doesn't allow for someone to be designated chair until it's accepted by the system, is it not?
Actually, it is.
It is,
Yeah,
okay.
so the petition.
I'm not familiar with that process.
Yeah, so the process is anyone can make a petition, right? It's only 200 words, and there's 7 elements.
But are you automatically designated chair upon presenting that, or?
Yes, there has to be a chair, and that's the committee. And he's not wrong that every person under the statute, for whatever reason, it does say every person that signs the petition that becomes a member of the committee. It does say that, but it never creates a separate committee. And it doesn't matter anyway, because let's cut to the chase. If you're talking about malice and reckless disregard, the person signing the petition is being told a lie by Mr. Veach and Mr. Murphy. So they are completely relying on the person telling them this that Mr. King does heroin, right? So I'm in Publix and I say, here's a petition that says Mr. King does heroin. And he says, oh, that's terrible, I'm gonna sign that. Here's a petition that says Mr. King does heroin, that says he doesn't do heroin. Well, I don't believe it. That's what heroin addicts would say, sign it. That person's not getting sued because they didn't make the statement. They are not the one publishing the statement. They're signing the statement. But if they took that statement and then put it up on their Facebook page, they would get sued. But they're not the ones that made and published the statement. That's Mr. Veach and Mr. Murphy. So I would not disagree that someone who goes and enters into the public arena and does a 100.361 recall petition and makes actionable defamation in that recall petition, yes, they are subject to getting sued. So my advice to people doing recall petitions is make sure you don't have actual defamation. What's the protection? The free speech protection.
Truth.
Anti-slap statute. That's what it's there for. It is there for that purpose, is to ameliorate exactly what he says. But we know that's the statute, and it gives them a lever, which is if they submit affidavits or other evidence that the petition brought by Mr. King and Ms. Woodson is wholly without merit and done for the explicit purpose of attacking constitutionally protected free speech. It doesn't say constitutional, it says protected speech. If they can meet those two standards, then the burden shifts to us to disprove them. We haven't even gotten past that stage yet. So we're not even at a point in the slap statute we can take the dismissal. So yes, there's no question that there's a tension here, as Mr. Kesey points out, but it's not this Armageddon of I do a recall petition and therefore I'm going to be sued and it's chilling to free speech. And by the way, people get sued in the political arena for defamation all the time. You mentioned Fox News. Ask Dominion how much money they got from Fox News. That was a presidential election issue that doesn't get much more political than that. The elected officials sue people all the time. The president is suing people for defamation right now. Sometimes he wins, sometimes he loses. But this idea that political speech is there's a guardrail around it, it goes back to this immunity question. And we know Barrett, this anti-768.295, it's not an immunity statute. It's not.
It's clearly not for the case law that we all reviewed today. Okay. I'm going to reserve ruling. I'm going to go over your notebook in a little more detail since I just got your one today, and then I will have my assistant let you know who's to prepare proposed order. And then even then, that's still subject to revision and changing of the mind, so to speak. So I may ask one or both of you to do a proposal for consideration. That doesn't necessarily mean that's the way it's going to go. So don't start sweating it out just yet.
If and when we get to that, whichever one it is it you want it in Word or do you
Word, yes.
No decision.
All right. If I deny it, what's your position relative to a stay?
It makes sense.
Okay. So if I asked you to prepare one, then you would include that. Okay. All right. You all went to mediation recently, and I understand there was an impasse, correct? Okay. And then you went to Mr. Mancini, who's a very good arbitrator, and I understand one side or the other did the rejection under 1.820H, and I did see the rejection was done properly. Thanks to Sanchez and Hernandez. If you haven't seen the Sanchez case that came out a couple weeks ago, make sure you look at that, because that reiterated Hernandez from the prior year. People are still messing up rejection notices, which you can see. So if you haven't read the rules, go back and read it, because a lot of people still are messing that up. But what I was getting at is, at the end of the day, there's obviously risks and repercussions of fee exposure. Whatever the decision isn't defeated, and there's flat fee exposure, there's appellate fee exposure, there's taxable cost exposure. So all I'm telling both sides is just be careful what you ask for, because in this case, at the end of the day, one side or the other might end up owing the other side tens of thousands of dollars in attorney's fees. And sometimes, and I have cases where both sides are paying each other's attorney's fees, and sometimes one side's much higher than the other. So I would encourage you, notwithstanding the impasse, to be at one final informal discussion. Any settlement discussion you had or may have, completely confidential, and no one's ever told about them. So before I make a decision and pull the trigger, I just ask that you all give it one more go, if you will. I'm not going to resend you to mediation, but see if you all can talk something out. And just let me know, it's today, Tuesday. Let me know Friday afternoon, yes, we've reached an agreement, or no, make a decision, and I'll let you know what it is if you ask for one. Okay? All right, thank you, folks. Thank you.
Wait, the record is
Not yet.